The man who invented the intermittent windshield wiper will finally get his reward. Ford today agreed to give Robert Kearns $10.2 million for failing to pay him royalties for all these years. He had asked for $141 million, but not to worry. Kearns has similar suits pending against 19 other domestic and Japanese car makers.
This civil case lasted nearly 10 years. In 1978, Dr. Robert Kearns filed suit in federal court for patent infringement against the Ford Motor Company. Later, he would file suit against additional automakers over the same infringement. Judge Avern Cohn presided, and attorney Jeffrey Sadowski's firm represented Dr. Kearns in the Ford Motor case.
This is the 1960s, 1970s. The automotive companies control this area. You've got this guy who's challenging the entire automotive industry. They can't control him. And it was a product that everybody all of a sudden wanted. So this is every man challenging the automotive industry in a time when the automotive industry controlled everything and winning.
The Constitution in Article 1 says that one of its powers is to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to the respective writings or discoveries.
The framers of the Constitution understood that you need to generate some incentive for people to come up with new ideas and new creations. To inspire those people, they came up with this protection mechanism. Patents, no more than 20 years. Copyrights, your life and being, and 75 years. Dr. Kearns came up with these patents in the 1960s. So he was an electrical engineering professor. To the general public, his invention was the invention of the intermittent windshield wiper.
Windshield wiper for automobiles that when it's activated, works the blades depending upon the moisture on the windshield. So if it's raining or misty, that water on the window sets off an electrical connection to control the motor of the windshield wiper. They began equipping their automobiles with intermittent windshield wipers. Kearns thought this was an infringement of his patent and tried to negotiate licenses with him. He was put off. They weren't interested.
His complaint was patent infringement, and also that Ford Motor Company had stolen his invention under confidentiality agreement, and he had a lot of facts to prove that. So we represented Kearns for the first roughly 2.5 years.
Shortly before the Ford case was to go to trial, Ford conceded that the patent was valid. So the trial involving Ford involved the question of whether or not the Ford mechanism infringed Kearns' patent.
And the jury found that Ford was liable.
But the jury got hung up on the amount of damages that Ford should pay. So after a period of time, we had a second trial on damages.
And he got an award from the jury of $5.1 million. Kearns' lawyers indicated they were going to appeal because Kearns wanted to appeal, and Ford came back and said, they basically gave him $10.2 million, twice what the jury verdict was, to settle the case.
So eventually he brought 4 separate lawsuits in this court. One against Ford, one against GM, one against Chrysler, and one against all the German and Japanese manufacturers.
When you throw yourself back in that time frame, it really was every man has a chance to protect his invention against the Goliath automotive companies.